What a mess. There's over 300,000 asylum claims. Your government, that will likely take 25 years to process the backlog. Your government has spent almost over $2 billion on things like hotel rooms for bogus asylum claimants. Bogus asylum claimants are getting resources that Canadians aren't eligible for, and here we are today.
Canada has a robust screening process.
I doubt it. This is not explaining it at all. Really? You have a robust screening system when someone that's on the child registry got into this country. It begs the question, how many more of these vile people are walking around our streets, in our communities, around our schools, around our community centers, around our children?
Minister, under Section 81 of the IRPA, how many warrants for arrests were issued last year, and what were the results of these warrants?
The federal government spent $1 billion on hotel rooms for asylum seekers.
I just want to be clear, there are presently, per your testimony, no asylum claimants in any hotel or temporary accommodation in Canada right now.
I said there's no asylum claimants in hotel accommodations, IRC. No, there isn't. I didn't say there. Obviously, there's.
So you're
correct.
not paying. So you're not paying for those asylum claimants that were in hotels to be in other places right now in any way, shape, or form.
So
This guy's garage. Like and subscribe.
Good afternoon, everyone, and warm welcome to all of you, and a special welcome to our Polish-Canadian student guests who are here today. We are very privileged to have the Minister of Immigration, Citizenship and Refugees here with us again to introduce the immigration elements of Bill C-12.
What a mess. There's over 300,000 asylum claims. Your government, that will likely take 25 years to process the backlog. Your government has spent almost over $2 billion on things like hotel rooms for bogus asylum claimants. Bogus asylum claimants are getting resources that Canadians aren't eligible for, and here we are today. Minister, the Canadian Bar Association, Refugee Lab, Amnesty International, and other legal advocacy groups have argued that the immigration provisions found in Bill C-12 are unconstitutional. Several of them have said that they are preparing for challenges, that there could be over 24,000 court challenges. Have you, Minister, directed your officials to begin preparing to defend the provisions of this bill in court in advance of these challenges?
So thank you very much, member, for that question. There's two parts to it. The first, you're talking about asylum. So our government is committed to rebuilding Canadians' trust in Canada's immigration system.
Thank you.
Making our borders stronger.
Question, and Chair, I realize but I asked a pointed question, so I expect a pointed response. Have you directed your officials to begin preparing for legal challenges, to defend those in court? You're asking us to support this bill. It is highly likely to be challenged in the courts. Have you directed your officials to begin preparing legal defenses?
So thank you for the question. Again, the intent of the ineligibility measures are to protect the integrity and the efficiency of the in-Canada asylum system against sudden increases.
Thank you. So I'll take that as a no. With your word salad, which is just really unfortunate because you are asking us to support this bill, which virtually every legal association in the country has said is unconstitutional, and you're word salading us on whether or not you have directed your officials to begin preparing it. So would you say that it is fair to characterize, given that what you've just said, that this is an attempt by the Liberal government to punt the mess of the asylum system to the courts?
So again, I don't know what salad you're speaking of, but the courts have confirmed that neither the Chair nor the Refugee Convention require a particular form of refugee determination process. In this legislation, we have the PROS system, the pre-removal risk disorder, the pre-removal order, and so the government's position is that these provisions are consistent with both the Charter and with the Canada's international refugee law obligations.
So I'll just ask one of your officials, is in the ministry's opinion, is the asylum deadline contained in Bill C-12 Charter compliant? Anybody? No?
Can I get a clarification, Madam Chair, the deadline?
Deadline? What
Correct.
deadline?
So it's the deadline by which that somebody has to apply. I think that there's an arbitrary timeline. Is that Charter compliant?
So again, our assessment based on the bill being tabled is the provisions are consistent.
Thank you.
with the-
Okay. So these provisions are going to be appealed. Minister, you haven't directed your officials to begin preparing to defend these appeals, so it's highly likely that many people will perceive the measures in this bill as a way to just punt, the government is punting this to the courts. Have you consulted with your provincial colleagues and come up with a cost estimate of the legal costs it will, cost provincial governments in terms of bogus asylum claims challenging the provisions in this bill?
Well, again, charter challenges would go through the federal court system, and that is the
Yeah, but there are
responsibility
legal-
of the federal government, and I've got the
Yes, but
justice officials here.
who pays for the legal aid, Minister?
That is the responsibility of the federal government.
But there's also provincial support that happens as well, too, right? And that's what you haven't done. You haven't gone to provincial governments, as you guys hashtag welcome to Canada, 300,000 plus bogus asylum claimants across the border from the U.S. I digress. A recent news story involved over 200 similar stories where applications for asylum were used. They used copy and paste language, and they all shared a similar immigration consultant. Why doesn't Bill C-12 contain provisions to require asylum claimants to state their reasons for claiming asylum orally on the record upon arriving into Canada to prevent this type of fraud?
Look, excellent. Look, these are excellent. That's exactly why we're here today, to study these provisions. These are to protect us against fraud.
Yes,
and
that's
about
not
fraudulent
so that's
claim.
not in the bill. Why isn't it in the bill?
The approach targets fraud in individual applications as well as a coordinated fraud scheme to prevent systemic abuse within the immigration and citizenship programs, and does hold actors
I don't
accountable.
think that's not in the bill. Shouldn't asylum claimants have to prove that they made their claim in a timely manner instead of making the government do so? And why didn't you include that provision in Bill C-12?
So there are clear provisions in this act
But not
in terms
that
of the
provision.
ineligibility rules.
Not that
the one-year
provision.
deadline and the 14-day.
But those are likely to be punted to the courts, and some simple switches, which could have prevented people from abusing the asylum system, you chose not to include, which is interesting. Minister, have you done any sort of studies on the totality of costs of bogus asylum claimants with regard to benefits across the across jurisdictions over the last 6 years?
I just recently met with the the provincial territorial, and we actually discussed, that was part of the discussion that we also talked about it. We talked about federal support.
What was the total cost?
I'm sorry, that's time. You're going to have to continue this in the next round.
But as we know, an important part of Bill C-12 concerns the ability of the government to share information, whether that's across departments or with law enforcement and with the provinces and territories. Can either one of you please outline how the bill's information sharing provisions will improve cooperation and coordination across government partners?
So, I can start and then I can turn it to for a bit more. But part of the bill that has been introduced would be to improve how client information is shared within IRCC and with federal, provincial, and territorial government partners. I think that is an extremely, extremely important part of the provisions because it would facilitate the sharing of immigration, of citizenship, of passport information with our domestic partners to help improve the integrity of government programs and really provide better client service. And of course, we take privacy seriously. There are safeguards. We will need to have regulations.
I just want to pick up on something you said to MP Sohi. You were talking about the temporary population, and did I hear you say that it's going to be 2029 before we see 5% of the population?
I believe that's the Francophone target. 2029. So, thank you for that. The 5%, 2027. Thank you for that. Thank you for that.
Which, if you don't mind, brings up another question I think we're all curious about. The levels plan is due on 2 days from now. I'm wondering, when will you be tabling that in Parliament?
Okay. Yes, thank you for that question. So the Prime Minister last week indicated that the immigration levels planning will be part of the budget that will be tabled November 4th.
Okay, all right, thank you. Now, to Bill C-12, it creates a new regulatory making authority in Section 87 of the Immigration and Refugee Protection Act. Essentially, it gives Cabinet the power to cancel immigration applications and documents en masse. Obviously, this provision was added to be used. So which applications do you plan on canceling?
So what I could tell you is the legislation was not drawn with that in mind at all,
So
in terms of canceling anything specific.
Okay, so just hold on then.
Please, yeah, go ahead.
So you created a new section, went through a lot of work to put this new law into the regulations with no intention of ever using it?
Oh, I'm not saying it will never be used. That's why it's there, but it wasn't created with that intention. It came out of COVID, quite frankly, and these were previously tabled or brought in as part of the 2024 level. So this is not new. It's been public for more than a year now.
Okay, so.
But it's, yes, go ahead.
So on September 23rd, your own official was here at this committee talking about this new power, and he said that it would allow mass cancellations, and he said, quote, for instance, issuing fraudulent visas, we would want to mass cancel those, end quote. So if you had this power today, would you recommend canceling permits for phony asylum claimants?
Look, that certainly would be a measure that I would, as the minister, be able to make recommendation on, but would have to go to government and council for them to, agree with me, and then reasoning would be so now we can do things on a case-by-case approach. The reason these are brought in is for trying to deal with public interest with, whether it's a health matter or a safety, national security, large-scale fraud.
So, Minister,
yes.
if you don't mind, would you agree with your official that this authority should be used to cancel the permits of asylum claimants who are here fraudulently?
Again, part of these would be used for large-scale fraud purposes.
Okay, so you have put some thought into how this would be used then. So what are some other situations where you would use this mass canceling ability?
So again, I will answer where I started. They are not designed to block people in need of protection from accessing the asylum system.
So who exactly is it designed to block then?
People that are going to be committing large-scale fraud, safety reasons, public interest reasons, and those reasons would have to be before the powers are used. They would be transparent because they would have to be told to the public, to the Canadian public.
So do you have some examples of those that you've talked about in your department?
Quite frankly, yeah. If you go back to COVID, there's a lot of things that had this legislation been there, that could have been done differently.
Like what, for example?
Like stopping the intake of all the applications that were coming in, as an example.
1 minute.
Okay.
Which we don't have the power to do.
So
at the
all
moment.
the applications would have been shut down, is what you're saying?
Well, it's what, and so the inventory kept going, but we were not able to bring anyone in. And as a result of that surge, that's what happened after COVID. That's part of what we're living today.
So we have a similar problem now where we have nearly 300,000 asylum claims, so a surge of inventory, as you would say. Is that the method you're going to use to get rid of that massive amount of asylum claims?
Again, they're not designed to block people that are coming here that are in need of safety. What they're designed for is to block groups of individuals that are really committing fraud.
Like 300,000 asylum claims? Should they be worried, the people in that pool?
So they're not going to give the government any new powers to cancel asylum claims or affect an individual's status.
Pardon me, but this doesn't actually give you any new powers? Is that what you're saying, this section of the law?
Gives government powers, but not on an individual one-on-one basis, because that power already exists.
So why is
it's for large-scale.
Thank you, Mr. Redekop. Thank you, Minister Diab.
Thank you. One thing I just want to clarify, like you mentioned about the mass cancellations. So, like mass cancellations is not for asylum claimants' application. Is it like, can you just clarify that those mass cancellations will not be for the asylum seeker applications which are within the system of IRCC?
That is exactly true. The mass cancellation does not apply to asylum claims. What it applies that what it applies to is, again, it applies to exceptional cases, which is not defined because it will be looked into in the regulations, but to give a maximum amount of discretion to government and council. But it includes things like the pandemic, like a regional health crises, like safety or national security threats that Canada might learn of and respond, again, to large-scale fraud. And if I can, the
1 minute.
legislative package provides for immigration document cancellation or suspension or variance of application for documents. Claims for refugee protection before the Immigration Refugee Board are not applications for documents and thus are outside the scope of these authorities. Any use of these powers, including vulnerable clients who would be impacted, would be carefully considered as part of a rigorous process. So they're only intended to protect Canada's public interests, as I said, such as safety, security, orderly migration.
Thank you so much.
Minister, how did Pakistani national Gulfam Hussain, who has a criminal conviction in the UK for adult sexual activity with a child family member 13 to 17 years old, get a visitor visa to come into the country?
Okay, well, thanks for that question. So all people applying to visit Canada are screened under our security regulations. When they get here, yes?
Mr. This vile rapist of a young girl is on the UK sex offender registry. So I ask you again, if they're screening, as you're suggesting, how did he get a visitor visa?
So again, Canadians are concerned when reports suggest someone who's committed serious crimes abroad has entered Canada. And that is exactly why Canada must continue to maintain and strengthen the screening and enforcement systems.
Minister, that's a talking point. I'm talking about an actual case of a rapist who came into this country, who from a G7 country, who was on the child abuse registry of the United Kingdom.
Okay.
Clearly giving me a talking point as an answer doesn't answer the question of how that person got into this country.
So IRCC can't disclose individual cases, but on this one it is public, and I will tell you what the court decision, because it's gone to court, so the decision is public, indicates the individual moved to Spain in 2020, then came to Canada on a visitor visa in 2023, did not disclose his criminal history on the visa application, and he has now been found inadmissible.
That was
and is being deported.
That response, in general, was in a National Post story on October 6, 2025, a day that you were the Minister of Immigration in this country. Okay? So basically, does it all it take for someone's background check? Is it okay with you if someone just doesn't tick off the box that says I have a criminal record as a proper screening for coming into the country?
So Canada,
a proper screen would have surely found this individual.
So Canada has a robust screening process.
I doubt it. This is not explaining it at all. Really? You have a robust screening system when someone that's on the child registry got into this country. It begs the question, how many more of these vile people are walking around our streets, in our communities, around our schools, around our community centers, around our children? Another case in point, Minister. Two ISIS members, Ahmed and Mustafa El-Didi, came into this country in 2018. They moved to my community in Richmond Hill. Shortly after obtaining their Canadian citizenship, a month later, they were found by CSIS. That was found out that they were plotting a terrorist attack in the GTA. CSIS actually found a video, which we were able to obtain as well. It's very easy. It's on the internet, of one of them dismembering a prisoner with a sword in 2014. Can you explain how that person that your government led into this country got into my community and it took CSIS many years to identify that indeed they were planning, only because somebody, I'm sure, whistleblowed that they were planning an activity, of a terrorist activity, terrorist act on Canadians in the Greater Toronto Area.
So the IRCC department is responsible for managed migration. Foreign nationals are all screened before coming into Canada. When things like that happen, we work with CBSA, we work with policing partners, we work in the system, and people are treated accordingly. And that's why you now have another bill in the legislature to deal with
Minister,
criminals.
You mentioned CBSA. CBSA
Yes.
officials testified before this committee that IRCC officials can and do overrule CBSA and issue permits even if CBSA has given a negative assessment. Why?
I'm sorry, who can?
The IRCC
Yes?
can overrule a decision by the CBSA. CBSA has found that the person is inadmissible, they get a negative assessment, and the IRCC has and does, on occasion, overrule the decision of the CBSA. Can you explain why your officials would overrule something like that? Why people would be allowed in our communities, on our streets?
Quick response, please.
Look, we're here to study C12, and it is part of detecting fraud. That is why we're here today, so that your committee is able to make best recommendation to the safety committee on if you need to make any recommendation on including in the bill regarding fraud, regarding whatever else you would like to make recommendations on.
Thank you, Minister.
Has the level of screening evolved over the years? We heard just now about cases from a decade ago. Has the level of screening evolved over the years in order to ensure that the safety and security of Canadians is always intact? To the officials, I'm sure it's a very detailed question.
So we have been modernizing for sure. There's biometric now and fingerprinting to help build confidence in Canada's system. Why don't I hand it to you and explain a little bit more in terms of how things have evolved, what exactly we're working on to modernize the system even more.
Thank you very much for the question, Madam Chair. So I might highlight a few areas that we have improved security screening, biometrics, and info sharing with partners to protect Canadians. So as you know, all foreign nationals are screened before coming into Canada to determine their eligibility and admissibility. In addition, we do have a comprehensive security screening assessment that confirms anyone who wants to come to Canada isn't inadmissible under Section 34, 35, 37, which are security, human rights, organized crime, war criminal type sections of the Act. So we make sure that we assess all permanent resident, temporary resident applications, and we work very closely with our partners in the security side, RCMP, CBSA, CSIS, to make sure that no one is inadmissible. Additionally, we collect biometric information to help build confidence in Canada's immigration perimeter and serves as a foundation of identity management.
Minister, under Section 81 of the IRPA, how many warrants for arrests were issued last year, and what were the results of these warrants?
Thank you, colleague, for the question. That's not under my purview in terms of the IRCC doesn't issue warrants. That's not something that we do. Again, as I said, we work with CBSA, policing partners, so on.
So I understand CBSA are executing it, but it's the ministry and the IRCC that determines whether this individual should be issued a warrant and...
No, it wouldn't be in the purview of IRCC.
Okay. So at least then the short answer is you don't know how many there are, and it's never been reported to the government or the Canadians.
It wouldn't be in the IRCC purview. If you would like CBSA to comment a bit on it, the official is here.
Yeah, that's okay. We'll move on. So, however, what it leads to the consideration is your ministry lets people in, and yet you lose track of them. And that was testified by RCMP and CBSA in previous sessions, that they don't know where these people are. So no wonder we're in such a mess with 300,000 these people, and a lot of them we don't know where they are. So moving on to the next question, under Section 82, people are apprehended under Section 82.2 powers of IRPA. So again, last year, how many people were apprehended and how many people were released?
So again, this is not, IRCC doesn't apprehend anybody. What IRCC does is we expect temporary residents to leave Canada when their authorized stay is over. If they do not, that's where CBSA and deportation and policing, if there's issues of other issues that take over.
So sounds like then it's a volunteer basis then, once you inform them. So moving on, last year, how many social insurance number were dispersed under Section 90 of the IRPA? Surely that's within the purview of the ministry.
Social insurance numbers?
Yes. These are
That would not be under IRCC, might be
No,
under
this is
Service
Section
Canada.
90. This is special, not your regular Canadian citizens or permanent residents. This is under the immigration purview. All right, so
We
we're
can
short
take
of
that
time,
back.
so
We can take that back. If
obviously
there's
you
a
don't have the
question,
answer to
we'll
that.
be happy to give it back to you.
So, Minister, do you report on a number of removal orders then enforced within the last 30 days interval? You don't have that either.
CC doesn't,
So where I'm leading to, Minister, is that a lot of these data are not available to Parliament, to Canadians, and how do we expect a transparent and, as you described earlier, a trustworthy ministry when none of these transparencies are provided and you don't have regular reporting to the Parliament and Canadians?
So, again, we're here to talk about C12. How do we strengthen it? What recommendations you do for the study?
Yeah, and that is my point, is you do have an opportunity under Bill C12 to enforce that and enhance that while you're at it. So let me just move on to the last point also then, therefore.
To answer that, I'm told these data are available on the CBSA website that you're asking for.
What data are you talking about?
Mr. McCord, do you want to respond?
Yeah, all of we publish on the CBSA website data on all of our removal inventories as well as the number of removals we're doing.
Including the warrant for arrest?
We don't.
Under this category?
You'll capture that in our wanted inventory. So
Okay.
if you look you'll see there's 4 inventories that we cover and for removals. There's where they're not actionable, not possible, wanted,
So in wrapping that topic up for Canadians and for Parliament, we expect to have a more comprehensive reporting, everything relating to immigrants and refugees as the purview of the ministry, including the data provided by CBSA. I just want to clarify one question you had earlier, one comment. You talked about the mass cancellation, and from my experience, inquiring for the Hong Kong pathway, well over 20,000 applicants, and a lot of them, the
That's time,
response from
Mr. Ma.
IRCC
I'm very
was-
sorry. You'll have to continue with that question the next round.
This legislation introduced 2 new ineligibility rules that would not allow an individual to claim asylum if they have been in Canada for more than 1 year or if they cross irregularly from the United States and wait more than 14 days to make a claim. Can you please explain why the legislation is designed this way and why that specific length of time?
Ms. Asfar?
I think in terms of why, because it goes to the policy rationale, it would be for Jason or Jean-Marc. In terms of if there are questions around the legal charter, I can respond. But in terms of the policy rationale, it would be over to Jason or Jean-Marc.
Okay, Mr. Hellman, please.
Provisions are designed to protect the asylum system in relation to the potential for surges given the volumes that we're seeing today, as well as to support deterrence for those who might be looking to misuse the system for reasons other than protection. So the 14 days is designed to interplay with the Safe Third Country Agreement with the United States. Right now, that agreement is in place and helps to manage the asylum claims across our shared border. It means that anyone anyone who crosses the border, in this case irregularly, within 14 days would be subject to the agreement and return to the United States. If 14 days has passed, the agreement doesn't apply to them. And in this particular circumstance, we're trying to mitigate those who are looking to evade the agreement and file their claim after the 14-day period. In relation to the provisions for 1 year, that's a date that's easy to understand. Many claims, or the majority of claims, are filed within 1 year of somebody's arrival to Canada, and we are then trying to deter potentially the people who are looking to use the asylum system to extend their stay.
The federal government spent $1 billion on hotel rooms for asylum seekers, and had to give the Niagara region a total of about just under $565,000. What was the reasoning, and was there an opportunity cost analysis to suggest that it was okay to take 1,406 prime hotel rooms off the market in Niagara Falls for 18 months?
So thank you for that. We knew at the time there were pressures with provinces, particularly in Ontario and Quebec, and municipalities. And so the federal government stepped up at that time and gave money to municipalities in your case to help them with that. What I could tell you is there's no one in hotel rooms anymore. Everyone has been moved outside. There's no hotel rooms being used anymore.
Sorry, Madam Chair, I'll get to that in a second. But the mayor of Niagara Falls and I had a chat about this, and he said when a tourist comes to the Niagara area, they need a room, and the impact on the food in the restaurants and the events and the tourist attractions. Even booking a simple tour of the falls, those are the major sectors in Niagara. We rely on tourism for economic success. In your analysis of this after the fact, have you done any impact analysis on what the negative impact on our regional GDP may have been as a result of taking 14 of the most prime location rooms out of the capacity of the city of Niagara Falls to market these rooms?
Again, I can't right now confirm or deny your specific facts because I don't know the specific facts of Niagara right with me. What I do know is there's no one in any hotel rooms anymore. That I know.
Again, Minister, I'm sorry, I have limited time, but that's really not the point. The point is Niagara Falls is only 85,000 people. You took the largest inventory of prime hotel rooms out of the tourism market for a year and a half. People lost their jobs. Tourism industries lost money. It had a huge impact, and I'm just curious as to how anybody could want to have such an impact on an important community like Niagara Falls to take 1,400 rooms all along the cataract out of the mix, out of the market for 18 months.
So again, I will go back. There were significant volumes. A shelter needed to be found. The federal government provided funding to those municipalities in order to do what it needs to do.
Okay. So, Minister, Mayor Olivia Chow in Toronto said she's going to have to raise property taxes in Toronto by about 2% to continue funding the asylum seekers. Now, you say there's no asylum seekers in any hotel rooms in Niagara Falls. Where are they?
They've all moved to accommodations. Again, some of the asylums are people that are working. They're going or going to school with work permits. Some of the asylum that you're talking about, these are people that are working in your communities as well. So it depends, and those that don't have valid claims to stay will be obviously asked to leave or deported. But those that do will be protected persons, and will have work permits. Again, I go back, Premier Ford was pretty loud a few months ago there. He wanted to do his own provincial, to give work permits. I could tell you the IRCC gives work permits for those that need to work after, obviously, they ensure there's no criminality and they do, get the medical test. So there's people that are also working and they're living in communities.
Okay, thank you for that, but they're living in communities, but the mayor of Toronto says she may have to raise property taxes by 2% to raise the amount of money that is still needed to respond to the economic impact of the hotel rooms that were taken off the market in Toronto. Similarly, in Niagara Falls, how do we recover from that economic impact, from that negative economic
15 seconds.
impact?
So funding in the beginning did focus on short-term housing. That is no longer the case. There is no short-term housing. It's now all long-term housing. I'll give you the municipality of Peel as a great example where they
Thank you so much, Minister. Thank you, Mr. Davies.
Continuing on this information sharing, so Minister, would the provisions that allow IRCC to share information with other government departments help the newcomers access programs and benefits from other departments to which they may be entitled?
Probably make it more efficient and speedier if they were able to have the provinces access the data, in a one source kind of shop. There's a number of.
How would that
quite
be
a bit of
beneficial to the
efficiencies.
provincial? How would that be beneficial to the newcomers?
Again, if I only use Canada, the federal government as an example, when they come in to immigrate, that's one application. Then they go into citizenship, they have to do everything all over again. Then they want to apply for a passport. That's a third application. Just in those ones alone, if we're able to combine all the information of an applicant, it would make it more efficient, less time consuming, and improve the integrity of the programs, but it's better for the clients. These applications take a lot of time, and many people go hire people to obviously do them. That's, it's very time and people are very worried that, did I adopt the I appropriately? Did I miss something? Did I whatever? So if we can help them make it clearer, then it helps us because we would not need to process it 3 times. So it's going to make it more efficient for us as well, so we can concentrate on other things that we do in the department.
Thank you. Our government has invested more resources into the Immigration Refugee Board, which has been increasing its capacity to hear the cases. But the system is still overwhelmed, leading to significant wait times for people waiting to start their new lives here in Canada, and at many times without their loved ones. Could you share how the mayors in C12 will help ensure more timely access to a fair hearing for the asylum claimants?
Yes, I can, and I just want to be precise in the information that I provide you. So again, it would be a single online application for the individuals. There will be legislative changes that would provide clear authority to specify the information and documents that are required when an asylum claim is initiated to begin with, including requiring the information submitted online. So this authority is required in order to make changes to the online application process, which will mean information usually provided to the IRB after referral, such as the basis of claim, is provided earlier. So they will get their information earlier, they will get it online, and it will be a single application. So once the claim is referred to IRB will then have all the information in order to do the hearing, as opposed to wait for different information to come from different places. The changes will ensure claimants are subject to the same requirements, whether they made their claim at a port of entry or inland. And it'll make it easier to process the claims. It should be more efficient for IRB, but also for the asylum claimants themselves.
what is the expected reduction in the wait times you think will happen with this change?
I'm not sure I would be able to answer the, do we have a question? Jason,
1 minute.
do we have?
Yeah, we can't quantify that. In large part, the time is also contingent on the number of claims that come in. But as the minister explained, we're changing both the period at the intake when people apply. We're changing how we review those claims to make sure the IRB can get information and process the hearings faster. We're also trying to give authorities to clear out incomplete claims from the system so that we're not spending time looking at documentation that's incomplete. And we are changing as well the ability for people to access designated representatives, people who don't understand the claim process, minors, so that they can have that support through the system to also ensure that they have fairness and get their claims as well through faster as well.
Colleagues, this is a 2-hour session. I wonder if we can if everyone would approve a 5-minute break.
Unreasonable.
5 minutes at the end of the meeting.
There's no protocol for this.
I know there's no protocol. We're just asking the
we'll
question,
leave it
and
there.
we're not losing time. We would actually extend
It's
it by
fine with the
5 minutes, Ms.
witnesses.
Rempel-Gardner.
We're okay to keep going.
This never happens. It's a 2-hour committee meeting. Like, does the
Ms.
minister
Rempel-Gardner,
need a
I'm
break?
asking you and everyone else here if we could take a 5-minute break. If you are against it, that's okay. So now you have said no, so we will continue. So now we are going to go. Despite everybody else saying yes, we will continue. We now have Ms. Rempel-Gardner starting the 4th round for 5 minutes.
Thank you. I'm here to work, Chair. Minister.
So are we.
Thank
Thank you.
Minister. Thank you, Chair. Minister, I just want to be clear. There are presently, per your testimony, no asylum claimants in any hotel or temporary accommodation in Canada right now.
I said there's no asylum claimants in hotel accommodations, IRC. No, there isn't. I didn't say there. Obviously, there's there's other municipalities have places, but not in hotels that are paid for by the federal government or anyone else. That's correct.
So you're not paying for those asylum claimants that were in hotels to be in other places right now in any way, shape, or form.
So we have transferred funding to municipalities, but there's no asylum claimants in hotels.
Okay, so basically what you guys have done is remove the hotel line item and force people out on the streets while transferring more money to municipalities. Is that about right?
I didn't say that.
Okay, thank you. I'd like to go back to the section on mass cancellations. So just to reemphasize what you said, you are saying that this section doesn't apply to asylum claimants, correct?
That is correct.
Okay.
These powers are used in exceptional cases for
Thank you.
fraud purposes,
So-
health crisis, like pandemics,
Okay.
safety, national security.
So fraud is not-
for individual asylum claimants.
So fraud is not mentioned in C-12 once, and the section that gives you power to cancel immigration applications, including permanent residence visas, doesn't include fraud. It's not, public interest isn't defined. So you weren't able to give an example, a specific example of where you would use this before. I'm just puzzled why you would be asking Parliament to grant you authority to cancel somebody's permanent resident visa without going through Parliament if you can't name an example.
So as I said earlier, happy to repeat, these are not meant to be used for individual cases.
Okay, so
These powers are for intentionally, public interest is not defined in the legislation to allow for flexibility for government to respond
Right.
to various measures that are not for individual cases.
But you talked about some of these examples being during the pandemic when there were a lot of fraudulent visas or letters issued to students.
No,
right?
no, I never said that.
Okay, but I'm trying to find an example where you would use this, because to me, it seems like you're trying to give yourself and your department more powers to correct mistakes in the system that they would have made in screening out, potential fraud to begin with, that affects real people with real lives. So you're telling people, like essentially you're asking Parliament to give your department the power to cancel people who've come to Canada on permanent resident visas and temporary resident visas without a lot of definition.
Absolutely not correct. The
Okay, then what would
Minister
the
of the
example be?
IRCC will not have these
But the
authorities.
government and council would, right?
The decision rests with government. That
Yeah, but not
would
Parliament.
issue an order in council that would be made public
But not Parliament. So,
to intervene
so
on the
if you were-
on documents.
Ms. Rempel-Garner, kindly allow her to answer the question.
Minister next week, and somebody asked you,
If I was where?
a Red FM panel next week, and a radio host said, who does this apply to? What would you tell the radio host?
Again, these are meant to protect us.
Who's us?
The government, the Canadian
Oh.
public. It's to protect
From
the
what?
Canadian public
From
from
what people?
safety, from
Allow her
major
to answer the question, Ms.
crises.
Rempel-Garner.
That's what it's meant for. It's to intervene
1 minute.
when there's, in the opinion of the governor and council, it's in the public interest to do so.
The government and council powers to protect Canada from groups of immigrants? Which groups of immigrants?
There's rise in exploitation. I don't think I need to tell you that.
Yeah, but why
there's
would
many
you-
that are brought in along, and we've learned a lot of lessons from COVID-19 pandemic that pointed to gaps in the authorities that currently exist
Why
in
wouldn't
Canada.
you just make the system work as opposed to punishing victims of human trafficking? This seems like you're literally saying that you're going to cancel whole groups of people's permanent residence visas? without
Absolutely not
defining
saying
what
that. And
That's
the
exactly
reason why
what the
this
legislation says.
legislation is to make things work better.
I think you're saying, you said protect Canadians from people. Which people?
It's to protect Canadians from public crises that are deemed.
Thank you, Ms.
in the-
Rempel-Garner. Thank you, Minister.
So you said that public interest isn't defined in the legislation. Are there any existing customary recognitions of public interest? How has it been defined in immigration law up until this point by either the courts or practice of immigration?
So thank you for that. So it is intentionally not defined in the legislation, as I said, to allow maximum flexibility for the government to respond in a range of unforeseen circumstances that threaten the public interest. When we say unforeseen circumstances, obviously I can't predict each and every circumstance, which is why we are here to put that measure in. But it is to protect the public interest, including, but not limited to, protecting the integrity of the immigration system, safety, security, health of Canadians, security of our border, respond to large-scale emergencies or other unforeseen scenarios. So each use of these authorities would be decided by the Governor in Council after considering all relevant factors, including the potential impact on vulnerable people as well as charter considerations. So to ensure public transparency, each order in Council is published in the Canada Gazette, which would give all of that information.
So if I understand this correctly, you're saying would be defined by an order in council?
Correct.
Okay. Next is that you also named a non-exhaustive list of cases, but they all seem to be very exceptional. Therefore, it's very narrow in scope. The application of this public interest provision within the legislation would be very narrow in scope. Is that correct?
That is the intent, that it would be narrow in scope. Something like COVID that happened, it would have allowed us to be able to do things differently.
Minister, do you agree with your predecessor that the United States, a G7 country, is a safe third country for the purposes of asylum claimants? Yes or no?
So the advice I've received is that it is.
So you do agree? Do you agree that other G7 and developed EU nations are presumptively safe democracies? Yes or no?
Look, I'm here to talk about C12.
So am I. That's why I'm here as well. Thank you.
So we
Thanks for
share with
letting me know
with the 5 countries all kinds of information when we screen applicants. That's part of the screening processes.
So you agree that they are presumptively safe democracies as well?
Well,
G7 and EU.
We
I'm
work
talking
with the
about
with the
G7 and EU
I5
nations.
countries.
G7 and EU countries was the questions.
Well, again, I can, we can go to global affairs if you like more detailed answer on that one.
Does C-12 bar asylum claims from safe G7 and EU jurisdictions, like we have barred claims from the United States?
Well, we have an agreement with the United States because we share the largest land border with them.
No, I understand. But C-12 doesn't have asylum claim, doesn't bar asylum claims from G7 and EU countries. Anybody could argue that a G7 or EU country has a judicial system on par with Canada. Yes, would you agree with that? Yes or no?
Again, we work with all the G7 countries, of course. Throughout.
Wouldn't it be helpful to have this power written into the legislation?
Again, you are here this is a study that the committee's doing, and you're free to make recommendations.
Well, you're the minister. We only get you here for 2 hours. I'm asking you what you think. Do you not
I appreciate
agree
you
that
want
we
me
should be
longer,
putting-
but
do you not agree that we should be we should be also looking at G7 and EU nations the same way we look at the United States?
So
they are safe countries.
So claiming asylum doesn't guarantee the right to stay in Canada. They still have to prove a well-founded, claim for fear, persecution, etc. And and it's on an individual case by case.
You have a huge backlog, Minister. You said you want to reduce bogus claims. I mean, they're bogus. Can anybody come up with a better argument? And it's a bogus claim if you want to come here from Portugal or England or Greece. Democracies like ours around the world have judicial systems.
So again, Mr. My member, it is a case-by-case approach.
Okay. On mass cancellations, Minister, are you saying that you want to punish victims of fraud?
My IRCC is not here to punish anybody. We're not the court, nor are we the enforcement section of the land. I mean, that's why you have policing. You have provincial jurisdictions that administer the justice system and policing, and we have CBSA as well in terms of deportation.
Here's who you are. You are a minister of the Crown that is responsible for our IRCC.
Correct.
That is responsible for the immigration system in this country. That you are also part of a government that has abysmally failed Canadians on the immigration file. If one looks just at the backlogs, the number of people, and good people, waiting to get responses when all of our offices are inundated across the country, you have a backlog. And we're giving you suggestions on how you can improve that backlog.
All suggestions and helpful comments are very much.
Well, you haven't proven that, with all due respect.
Well, I mean, the committee's here to give recommendations.
We passed amendments in this committee that you managed to discuss with your good friends from the NDP, and you're going to vote those amendments down, Minister. Your record, personally, and the record of your predecessors, is that you ignore any amendments that come from other members of Parliament. Well, I have news for you and your government. We are all elected to represent Canadians, not just you.
Absolutely, you are correct. I am a member of Parliament just like you and everyone else.
Okay,
and we all have one voice.
We're making suggestions to you.
In Parliament.
We're talking about G7 countries. We're talking about EU countries. And it's ridiculous to assume that they should not be treated the same way we'll be treating people coming in from the United States. You wouldn't agree with that?
Again, asylum claimants are treated on a case-by-case approach.
Do you know how many asylum claimants are in this country that have a criminal record? That's been reported here by officials to this committee in this session. Asylum claimants have criminal records.
Again, that's why we have the enforcement section.
You have the enforcement
and
section?
we have policing.
How many people are in the country right now that you let in that have criminal records?
Thank you, Mr. Menegakis. Thank you, Minister Diab.
Minister, you mentioned in your opening remarks that the provisions in Bill C-12 that would allow the federal government to manage immigration documents on a larger scale would then allow Canada to stay prepared for future crises like pandemics. Can you tell us how the mass document change authority set out in Bill C-12 would look like in practice?
Yeah, sure. Would you like to take that one on, Tara? Just give me a sec.
Absolutely. So some of the ways that we can use the mass authorities, we've spoken a lot about cancellations and backlogs. However, this is not something that we built with a cohort of people in mind or a reason in mind. There are crises that come about, and we need better tools to deal with them in the immigration system rather than a case-by-case analysis. One example that I might offer that we haven't talked about is the ability in this situation to also mass extend documents. So something that we learned during COVID is we all know that we needed a lot of healthcare workers, for instance. So in this situation, we could try to define, as the Immigration Department, that it would be in the public's interest to mass extend healthcare workers so that we wouldn't have to do it on a case-by-case basis, make people reapply for an application, find the job, et cetera, et cetera. We could make that argument to the Governor and Council. The Governor and Council can do the assessment, make sure everything is charter compliant, and if so decided, would be published in the Canada Gazette, and then we would have the authority in the Immigration Department to mass extend in the public interest.
I'd just like to go back to the mass cancellation powers because, Minister, you really haven't outlined where you would use those powers. You mentioned preventing fraud that happened during the pandemic. You keep talking about the pandemic. I note a lot of people that are on the Hong Kong pathways, for example, came in during the pandemic. What's to stop you from using, or not you, but the government, from using this power to cancel the visas of everybody here on the Hong Kong pathway? Like, what would stop it, conceivably, if we let this pass? What's the safeguard from you doing that?
Well, actually, there's a lot of safeguards. I already said I'm not going to have any singular power.
But
it's not in the power of the minister. It's in exceptional cases. It has to be deemed in the public interest.
Like
goes
what?
to the Governor and Council. Has to be charter compliant.
Like what?
There's a lot of safeguards in the system.
Like what?
I've just explained like what.
But the government here, like we've seen examples where the government has done crazy things, quote, in the public interest, like.
Well, that might be your opinion. It may not be someone else's opinion.
One of your former colleagues talk about using tanks on people. That actually happened during your government's tenure. So what is to stop, like I want to know, because you're asking us to vote in favor of this bill, what is to stop you from en masse canceling the entire PR and visas of everybody who's on the Hong Kong pathway right now? What's the safeguard in there specifically?
Again, these are not meant to cancel en masse.
But you just said it was to cancel en masse. It wasn't for
it could be extended.
Cases.
It could would have to be in the public interest, and that is why the regulations will specify some of these as well.
Interest?
And it would go to the Governor and Council. There's a cabinet committee. There's all kinds of all kinds of ministries would be involved.
So what I take from
legal justice would be involved. It would have to comply with our charter.
You want Parliament to give the government the ability to kick mass groups of people out, undefined, who they don't like. That's what it sounds like to me. You're not being specific with regard to safeguards here. You're literally asking Parliament to circumvent laws that protect charter rights and to mass cancel entire groups of people who could be here, and you can't say who. How could I go to ethnic groups in my community and say that I could vote for this? This is actually bananas and so anti-Canadian. So what are those specific safeguards? You haven't defined it in the legislation. You're sitting here blathering, and you're literally asking us to say, yeah, we should give the government to just cancel mass PRs. Like imagine you sitting on Red FM tomorrow. Are you going to be saying the same thing to them that you're saying to me now?
Absolutely, yes, I will be.
Thank you for that.
These are not designed to block people that need protection from accessing the system. These powers would only be used in exceptional circumstances when determined in the public interest. There are safeguards that are built in here. It would have to be charter compliant. We will have justice and other officials and other departments involved. That is how you run a country, believe it or not, member, and that is part of ensuring that we have the tools needed to manage migration integrity.
So this is how how you run a country. You ask Parliament to give you powers to cancel, as you've said, permanent resident visas, temporary resident visas, en masse, without defining in what situations you would do it, with no
1 minute.
examples, and then you say that's how a government should be run? That sounds like an authoritarian dictatorship to me. Why should I give you the powers to do that? That sounds absolutely
Again, these
insane.
are not powers for any one minister. These are triggered in exceptional circumstances. It is intended for governor in council. It is in the public interest. There are safeguards. It would be charter compliant. There will be a lot of legal analysis that goes into it.
Would you use this to cancel? Could you? What's to prevent the governor and council from canceling all of the people who are here on Gazan temporary visas right now?
Again, these are used in exceptional circumstances, and when it's deemed in
Like
the
what?
public interest, it's to manage the immigration system.
For the record and for the
make
analysts,
it more
I would like to
integrity.
note that the minister has not noted what those exceptional circumstances would be, and that is crazy.
And that is the
Unbelievable.
purpose for the legislation.
order.
It is meant to give...
Point of order, Mr. Fragiscaros, and it's time as well. Yes.
I'll withdraw it, it's fine.
Okay. Thank you, Ms. Rempel-Garner. Thank you, Minister.
How would the authorities granted in Part 7 of C12 assist in maintaining the integrity of our immigration system during a potential cyber attack?
Actually, that's an excellent example. That's where mass authorities, that's where we can use these mass authorities to ensure that that we would have the authority to deal with situations exactly like that, because there's a lot of sophistication that is going on around the world with people that are doing a lot of criminal activities, exploitation, and so on. So again, we are in IRCC. We have new digital technology that is transforming our services to simplify our processes, but it's also to detect a bit better these frauds. And again, we work with our partners as well to not just CBSA, but also CSIS and as I said, our I-5 partners, United States, United Kingdom, Australia, New Zealand, and I guess we're the fifth, Canada. Those are the, to share information as well, that when we process cases or when we also look at that.
Do you use AI in any application for any processes in the Immigration Department? So you don't? Okay.
Not
So
to process applications.
my understanding is that
It was a
AI
question that
is-
had come to me before, and I asked the department not to process applications.
All right.
They're
My
done
underst-
by human beings.
Well, my understanding is that there is a software package that is used by IRCC to screen applicants, visitors who want to come to Canada, and occasionally it comes up with problems, like somebody who says they're going to go canoeing in Northern Ontario in January. This software, are you saying that this software is not in use in the
15
IRCC
seconds.
or CBSA?
No, so what we use is a triage model, that it's an Excel spreadsheet. It's not an automated or AI software.
I'm curious, why do naturalized citizens have to can have their data shared? And two, the sharing that happens for permanent residents, temporary residents, the personal information, is it very limited in scope? Will it be very limited in scope, or will it be the wholesale information shared to different partners, including provincial governments?
So because of privacy, obviously, we take that quite seriously, and to protect the personal information of applicants. As I said before, all information sharing agreements, whether it's within the federal governments or within federal, provincial, territorial, would be in writing, and it would include strong safeguards to protect people's privacy and charter rights.
Thank you so much, Minister. Thank you so much, Mr. Zuberi.